if this isn't a civil authority shutdown, what is? Right? Like, I mean, this is so clearly the action of a civil authority to stop your business.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Good morning and welcome to The Defense Never Rests. My name is Scott Ribney and I'm guest hosting for Trish Baxter today. I am very happy to be speaking with you. This is a special edition of The Defense Never Rests. This is our COVID-19, the insured's perspective. And I'm very excited to have with me Tony DiIulio of the law firm of Wheeler, DiIulio, and Burnaby. How are you this morning, Tony?
I'm doing well, Scott. I really appreciate you having me.
Oh, thanks for coming on board. And for those of you who are watching this, I would just ask that you go and subscribe to the podcast, the Defense Never Rests. You give it a 5-star rating. I think what you're going to find from today's presentation, especially, is going to be really insightful comments and commentary from a law firm and an attorney who has really been at the forefront of a lot of the first-party property insurance issues, not just in recent memory, but Tony's firm has been doing this going back decades and decades in Pennsylvania and really headed up some of the most important policyholder decisions in the state. And Tony and I have gone back and forth on a number of cases over the years together. So this is going to be a fun and insightful program, I'm sure. Tony, I'm sure like me, you've been following a lot of the COVID-19 issues with particular interest, not just because the courts, in our state have been shut down for a period of time, but also because it directly impacts the type of work that you and I do.
Yeah, we've since this first started, we had a partnership meeting and with the attorneys to discuss kind of what this is going to mean for the industry. Since our firm focuses on these insurance disputes, we knew that this was going to be a big issue from day one when it comes to the business interruption coverage for businesses, because it's been such a huge impact on every business, small and large. So how the carriers are going to be handling this with the insurance coverage issues has been of particular importance to us. So we've sat for CLEs for these things. We've done research through the case law through Pennsylvania and New Jersey, and are really following this as closely as we can.
Yeah. And, one of the reasons I reached out to you, I'm going to be completely honest because, I've been doing the exact same thing, on this, looking at it from both the carrier perspective, because I represent the insurance carriers, but also trying to put myself in your shoes here, because that's what I think a lot of the people out there really need to hear. And as I was looking at some of the posts here and the articles that are being written, I'm sure they're the same ones you've looked at. When this started to hit, a lot of the attorneys on both sides of the aisle, for whatever reason, were taking a black and white approach to this. And I'd say the vast majority of them were flat out saying, this is not covered, period. And there were a lot of carriers out there writing, I'll call preemptive denials, before a claim was even submitted. And you're shaking your head because you've seen, I'm sure, some of those letters online as well from the carriers and the positions on that. We're going to talk about those in a little bit. And I thought, you know what? This is probably a great opportunity for you and I to do something that we really have never done before. I mean, we're used to sitting across the table from each other in courtrooms and in hearings and in depositions, but for us to sit down and say, okay, for everybody out there, for insureds, for insurers, we're getting together two people who live and breathe this stuff every day, and we're going to do a deep dive into some of these coverage issues, what it means for both sides of the aisle, because it's important that I think everybody hear this.
And I appreciate that, because the stuff that is getting out there, I think you're right. People are taking these kind of broad stroke brushes against what these policies say. And as you and I both know, no two policies are exactly the same. So to take that broad stroke I don't think is appropriate. And I think doing a dive into what these policies actually say could be invaluable for a lot of people, both on the carrier side, determining whether or not they're going to cover these losses, and for the insureds, whether or not they should make a claim and whether or not there really is a fight to be had.
Absolutely. And, I think there's one unifying feature with all of these policies, whether it's a business owner policy, a commercial policy. When we're talking your basic coverage that's out there for the damage to the structure, which would include a business interruption claim that flows from that, they all start with this language, direct physical loss or damage. And a lot of the people out there have been saying, well, a virus is not a direct physical loss. And they're keying in on those three words only. What do you say to something like that, to those attorneys and that kind of narrow focus?
Sure. Narrow focus in general in our field is inappropriate. You never want to lock in on one set of language when you've got language that has an or provision. Anytime you've got that disjunctive or, you've got an opportunity to say, well, which one is it? Direct physical loss, or is it just damage? And to make that distinction and say, the carriers made a determination to say or there. So you can make an argument that you can have direct physical loss. And I believe there is an argument that if you had the virus on site, it's direct physical loss. I'm pretty confident that the courts will come down that way. But the real question is going to become, well, what if it's somewhere else? You don't have the direct physical loss, but maybe you have damage, right? If you can show that there is damage to insured property, which can be anything from loss of business to accounts receivable that is very often specifically named in the policies as a covered aspect of personal property, those things can be enough to trigger that coverage that you need.
Now, you and I practice in the Northeast here, New Jersey, Pennsylvania. I get up into New York. I don't know how much I think you're getting up into New York now, aren't you, your firm?
Yeah. So I have an attorney up there who I've been doing work with. I'm doing reciprocity up there. And then I've also got my reciprocity in Virginia. So we're expanding across the East Coast with, counsel, either of counsel or local counsel that we're working with. But yeah, we've been doing a lot in this kind of Northeast area.
Yeah. And I bring those three states because at least in terms of Pennsylvania and New Jersey, there are some important differences between those two in terms of clarity from the courts on this direct physical loss or damage issue as it relates to something other than, the physical storm traditional damage that we see, or a pipe break, when they get into something that's a little more less substantive, like a virus or noxious fumes or something like that.
Sure. And it's interesting because through the case research that my firm has been doing, I'm sure it's the same stuff that you're coming up with. As these states are making these determinations, we're finding cases that have kind of swung both ways in a lot of these states. New Jersey appears on its face to be a little less favorable, but there are cases out there like this customized distribution services versus Zurich, where the court came down and said, for direct physical loss to be triggered, you don't really need direct physical loss, which was a great opinion for me. Not so great for the carriers, but they in essence said you don't need a material change or a chemical composition change in a product or in structure to be damaged. It could be enough to have a loss of value or loss of marketability. And those types of the opinions are the things that we're going to really need to focus in on as plaintiffs' attorneys to say, look, if we're going to be making this argument that there's been direct physical loss or damage to a property, we need to be sure to show these courts it doesn't really have to be physical damage in the classic sense of, water damage to your property or a tree fell on it.
So it's going to be more along the lines of, almost we'll call it like the noxious fumes type cases, where you've got the gas leak down the road, or the pipeline leak, and all of a sudden a business has to close, not because it had damage, but because of whatever chemical has been released inside the building. Or I've even heard some people talking and making reference to the ransomware cases and some of the decisions there about direct physical loss, because that was defense number one in those for the longest time, is that these don't constitute a direct physical loss to the actual equipment. And the courts seem to disagree, looking more on the use and function, similar to what a lot of businesses are going to be having here.
That's exactly right. The use and function, I think, is going to be a huge focus, and the ransomware is a perfect example where you don't have a physical loss, you don't have physical damage to the unit, but you've got coverage for it under your policy. It's the same way as we were starting to do reviews that accounts receivable are a named insured item under these policies, often under the personal property of the businesses. And for an accounts receivable to be covered, you can't have physical loss or damage to it. It's impossible to be physical damage to your accounts receivable. So the argument for the court would be, well, look, these carriers are providing coverage for items that it is impossible to have physical loss to. So that must mean that there is covered losses beyond the physical nature.
Mm-hmm. Now I'm going to kind of jump ahead real quick to the complete opposite end, because as I've had these discussions with different attorneys online, and they back off a little bit from the direct physical loss issue, the next response always is, well, there's a virus exclusion in the policy. That applies and bars everything. I know what my thoughts are on that, but I'm curious to hear, what your thoughts are in relation to, that kind of second line of defense here.
Sure. There's a few. First, in the same sense that we were talking about before about whether or not it's physical loss or damage, I would intend to use the virus exclusion in some policies to say, well, look, if this policy doesn't have a virus exclusion, the fact that virus exclusions exist is evidence that viruses are direct physical loss to property, right? Because if they're not, you would never need the virus exclusion in the policy, right? So the jump would be made of, if the virus exclusion wasn't necessary, they wouldn't put it in. So if it is there, it must mean that if it's not, it's covered. In addition, there's some good case law out there that suggests that would not apply to a loss at your property if you don't physically have the virus yourself. Although some of the language is direct or indirectly applied, not all of it is. And a dive into that policy language to make a determination as to whether your loss was actually the result of the virus, or if it is really only the result of the civil authority or the government shutdown or other loss to your business, which could be deemed damages, that exclusion wouldn't necessarily apply.
Right. And I think we can agree, if we're just talking the policy language only, there are some policies out there that have a very good virus exclusion that arguably is going to be very tough for an insured to overcome here. But the other point you made, and I think it's worth repeating here, and it's worth everybody hearing, is that you can't just look at one policy form that's available out there on an insured. You got to go back and say, okay, and this is what you and I are doing with all the matters we're looking at here is, okay, what form was actually on the policy that the insured had, and were it the right forms? Because
and that issue of how insurance policies, people seem to think that they're all the same, is one of the biggest frustrations in the industry. I mean, there's whole books that are written about it. There's a fantastic one called When Words Collide that focuses on multiple chapters on that issue alone, because they market insurance as a commodity. Like, milk or oil, all of it's the same in essence, but that's not the way insurance is written, which you and I know. I mean, you have multiple carriers who you work for, and every one of those policies has different language. So going at these losses all the same way, regardless of who the carrier is completely the wrong attack. Something else I wanted to mention, by the way, when it comes to this direct physical loss or damage aspect, a number of the policies that we're seeing say risk of direct physical loss or damage. And that one little phrase, risk of, can make a huge difference in how these claims are argued, because as soon as you've got that risk of direct physical loss or damage, you've got a much wider breadth of coverage triggers. And the simple risk of something happening down the road, like the virus getting on your property, is enough to make that trigger, really, in my opinion, without question.
Do you think that risk of can apply to, let's say, and we'll bring it to our home state of Pennsylvania. I'm sure you heard of that case where the woman was going around coughing on the vegetables in the small boutique supermarket here,
Yep.
claiming she had the virus. Well, let's say there's a business right next to it who gets wind of that and says, okay, I may be at risk of this because this woman who did this next door to me could have come by my property, or I have video of her coming in, but not necessarily doing the same act. Is How close in proximity do you think that needs to be for it to really kind of stick here? Or is it just going to be the facts of the case and what judge you're in front of? Is it really going to be that simple?
I think it will be incredibly fact specific. The risk of language has always been something that's been argued in our industry because it does create such a broader breadth of coverage, but it can't be infinite, right? My house that I'm sitting in right now has a risk of collapsing. Sure, right? Any day it could collapse. It's not going to. I don't anticipate it, but
I hope it doesn't.
Right? Yeah, right. Certainly. So, I can't go and make a claim just saying, well, someday it's going to collapse. I've got a risk of collapse, right? So there's got to be some type of proximity argument made fact specific. But I think in that scenario, or really any scenario in this country, right now, given the how widespread this has become, it's a real risk, right? This isn't just maybe it happens kind of thing. But it's unlikely. I think almost anybody that has that risk of language in here is going to have an arguable case. Now, whether or not the judge is going to rule in their favor, who knows? But it's certainly one that's worth investigating and likely filing.
Right. Now, one thing I'm not seeing in a lot of the cases that are filed, and I'm sure like you, we're both keeping track of all of these lawsuits that are out there, seeing who's filing them, what are they arguing. One of the things that I'm not seeing argued that much, but I'd be willing to bet it is at the forefront of your mind, is the reasonable expectations of the insured in all of this. I mean, that's not really been talked about that much. Can you, because I know you deal with these insureds, these people, these businesses, maybe offer up some insight into, okay, here's what their thinking is, obviously without getting into specific clients or whatnot, but just generally speaking, how the insureds are looking at these types of coverages, because I think that's something then that we do need to talk about in the bigger picture of this coverage, dispute.
Sure. And this is one of the biggest issues that we've been dealing with because, for the past couple of weeks, one of the things that's been keeping me most busy is doing these policy reviews for clients. We've decided, we made a business decision to just do free policy reviews for anyone that sends us a policy. We'll look through it and give kind of our 2 cents on what we think is covered, how to put a claim in with your carrier. And a lot of that has been started because a client will come to me and say, hey, I'm hearing all this stuff on the news. I'm getting this letter or this declaratory statement from my carrier saying I'm not covered. What's the deal here? So there's a few aspects of this that I kind of want to bring up, and I want to start with the letters that are going out. I think the carriers first are at a big risk if they send those letters out, but I think they're doing it because they want to have that argument down the road to say, you didn't have an expectation of coverage because we told you there wasn't coverage. So I think they're doing it as a strategic decision to kind of to shift that answer so that when they later down the road have to argue what were your reasonable expectations, they can say, well, look, before you filed this claim, you didn't have a reasonable expectation of coverage because we told you it wasn't covered.
But doesn't that fall apart, Tony? Because and you and I have had this fight a lot in terms of the reasonable expectations. It really applies to the insured's expectations before the loss occurred, right? Not necessarily after, but whether they're anticipating the claim or not.
Correct. So the real question is upon signing the contract, right? When you first take out that insurance, what is your expectation? There could be an argument that it's upon renewal, but I generally make the argument that it's upon purchasing of the initial contract. So I do think it's not a strong argument by the carriers, but my guess is that's why they're doing it. but it opens this door for potential bad faith, because if the court comes down the road later and says, no, this policy does cover it, the very next suit that comes out is going to be an intense bad faith litigation that says, you told all of your insureds this isn't covered. Countless numbers of them probably didn't make claims because of this, and you were misleading them, which we now know the court, has said it's a covered loss. It opens up a huge amount of liability, especially when you take into consideration their responsibility to investigate these claims. Unfair Claim Settlement Practices Acts are going to kick in. It's going to be a lot.
And one of the things sorry, go ahead.
No, I was just going to say that's kind of the first aspect. But what were you going to? I want to know what you were going to say.
Well, no, I was just going to kind of add on to that. And again, I'm not betraying anything here on my side of the fence. It's the way the law is. But in Pennsylvania and a lot of other states, if an insured can prove they had that expectation of coverage, that can override even the clearest of exclusions.
Mm-hmm. So, and that's kind of the next step of this, right? So you first I want to talk about those letters and why I think they were going out, but then you get to what these insureds are expecting when they send me the policies. And they're being guided by, these press conferences that Donald Trump is saying, insurers need to cover these things. And I know we should talk about that in a little bit too, and what that means for the government trying to step in. But these insureds on the baseline believe that if their business is shut down and interrupted, they have insurance coverage for that. I mean, they have business interruption coverage. So they come to me and say, what's going on here? Why is this not something that would be covered? A lot of small business owners are not savvy with insurance by any means. These owners, these men and women, just get what they're told to get. They go to an agent, they say, this is my situation. Give me whatever I trust you, give me what you need. And they think that they've got coverage for when their business has to shut down, and it's not their fault. And what they're finding out is there's a lot of carriers pushing back.
But don't you find as well, and we've talked about this before, when you're talking about businesses, shouldn't there be a certain level of sophistication about that? They're setting up, they're employing people, they're doing all these things. No different than, say, a Fortune 100 company, except for the scale of the business themselves. And if they're going to, say, the wrong agent or broker and not getting the coverage that they really need, shouldn't some of that fall on the individual and applicants as well? I'm not saying in the big picture as it relates to the coverage themselves, but for this reasonable expectation argument, where we're kind of missing the middleman here, the agent or broker, aren't we?
Yes, to both of those in some degree. I've always understood the argument that, look, you're running a business, you should understand what you're getting yourself into when you're running a business. But one of the things I've realized as I've gotten older is that a lot of the times we still don't know what the heck we're doing as adults, right? We put on these faces like we know what we're doing, and that we've got this all figured out, but we're all just people trying to kind of figure it out as we go along. So the reality of it is that the business owners are just ordinary people trying their best, doing what they can to figure this stuff out. But there's just not enough hours in the day to become, informed on every aspect of a business. That sometimes you just got to rely on other people, which is why I think these claims with agents, which I haven't seen any of, I don't know if you have, but
no, I haven't really either, which is shocking to me, honestly.
Sure. I mean, a lot of these agents and brokers have fiduciary responsibilities to their client. And if that fiduciary relationship exists, and if there is reliance on the agent or the broker, there's going to be real claims that come out and say, hold on, you told me I was covered if my business shut down, and now I'm not. What's going on? You screwed up. And the kicker is there are policies available that would cover this. I've had some that have come through that I actually had a policy last week come in that actually says coronavirus is a covered loss. It uses the word coronavirus. So there are policies that cover this. There are options out there. So it's going to be really hard for an agent to come back and say, I'm sorry, there really was no other choice. to get coverage for this because, every policy has a fire risk exclusion, or, everyone doesn't cover this, because there are options. So we're going to have some real claims, I think, against agents and brokers saying you messed up.
Do you think that part of the analysis is something that is being overlooked right now? Meaning, the insureds should be looking at the agents and saying, what did you tell me, or what did you sell me, if they specifically asked for a certain type of coverage? And by the same token, the carrier should be going back to the agents or brokers saying, what are you telling to these people? What's in your file?
Yeah.
Because we both know that, you're going to try and say that the seller, the producer of the insurance, that agent or broker, is going to be the agent of the carrier. And I'm going to be on the flip side where I can say, no, they stand on their own 2 feet here. They're separate. And what they did, if they screwed up, it's going to be on them. But it's going to be the documentation they have. And some of them are going to be able to document it very well and say, no, here it is. Others, the information is going to be lacking. That's just the reality of, the world you and I live in here. And we've seen it countless times over.
Yeah, it's rare that I get an E&O claim against an agent or broker that has a really in-depth full file. It does happen. It's every once in a while you get a company that is really good at keeping a log and noting phone calls, but 95% of these cases are he said, she said. And the reality is for the courts, a lot of times the juries are gonna side in favor of the business owner, especially given what's going on. I think carriers are going to have some real issues saying, look, you're this huge company that's making billions still. You haven't been hit by this. Why aren't you paying up? But I think the problem, kind of to the original aspect of the question, is that a lot of people are overlooking this relationship between the agent and broker and the insured. My fear still to this day, and will continue for a while, is that people who are filing these claims are just looking for their 5 minutes of fame, and that they're just latching on to the very first case they can get, and they file it, and it's gung ho after that. But I don't want bad law to be created because of bad cases, and I really don't want attorneys who don't focus in this area, who don't have the expertise or knowledge to really dive into these policies, to be arguing them, because if they miss something like that, or make the wrong argument about physical loss or damage or what that means, it can hinder everybody else after that, because the first decisions that come down on this in every state are going to be cited like crazy by both sides, depending on who it's favorable to. So, that's the risk that I'm afraid of, that things like the agent are just being overlooked because these are attorneys that don't do this very often.
Right. And, that's something I've kind of lamented at too. And nothing against those attorneys. I'm sure they're exceptional attorneys in their field,
Of course.
And you may have someone who's the best, let's say, medical malpractice attorney out there, whether for the plaintiffs or the defendants, but they may not fully appreciate the coverage aspect of this the way you and I do. And, and certainly the implications from other states. And we've seen this just with, say, the overhead and profit issue, over the past 5 years, how that's evolved from state to state, and how a decision in one jurisdiction snowballs into another here. And I guess that's the question I'm going to ask next is, because I see the underwriting being of such an importance now for these types of claims and the broker relationship with everybody. If a carrier is issuing these, kind of preemptive denials without doing that investigation, are they doing it at their own peril?
Absolutely. I think there's a real risk to them when these claims get litigated and that underwriting file comes out and says, a claim was made over the phone and we denied it the same day without any investigation, without anything going on, or preemptively denied them through these letters. I think they've got a real risk, because they're doing exactly what I tell my clients not to do. They are generalizing everybody, right? I tell my clients, don't generalize the policies, don't generalize your loss, because every single one is different, right? There are nuances to every single one of them. So to take that broad stroke is just irresponsible. I think it is an attempt to limit claims when they know that they're going to be flooded with claims. And I think that they're doing it to save time and money. And I just think that's a risk to them that probably isn't worth it in the end.
Does it make it easier for someone like you, though, when you get that kind of letter, you see that posting on the company's website, to then start getting into what I'll call the pattern and practice discovery of other claims? Because a lot of times, there'll be a request in litigation for other claims that the insured may have denied. And, you want it, I don't want to produce it. But when you have something like this that's out there that paints everybody with a broad stroke, does it make it easier for you to get in there and say, look, I've got this extra contractual claim for bad faith. Here's a letter where they're just denying these across the board without conducting any investigation. Here's how you connect the dots to then force the carriers to give you that information.
Yeah, I think that's exactly right. When some of these states focus on patterns of practice across the industry. Others don't require that to get these bad faith claims in. But certainly when you need to show a pattern of practice, it opens the door without question to say, look, I need to know how they're doing this for every other claim as well. Because we have this letter suggesting that it's been exactly the same. That is more than enough to open the door to force these courts to say, yeah, insurers, you've got to turn over that underwriting file for all of those claims to see what you're doing. One of our issues from the plaintiff's bar side when it comes to these insurance claims is there's nobody that really enforces the insurance companies because the insurance department is tiny. It's not big enough to enforce. So we've always kind of felt as the plaintiff's bar that it's our responsibility to kind of keep them in check. So, we've used those policy type arguments with the courts before to say, hey, look, we're the ones that need to make sure that this is going the right way. We now clearly have some evidence to suggest this is happening on a broad scale. Let us look into it. Let us find out if this is really happening, because that's what the purpose of the bad faith claims are, right? To see if there is this pattern of practice. So let's dive in and figure it out.
And also with many departments of insurance, their job is not necessarily to get into policy interpretation and coverage decisions. They'll look at the timing of it, if investigations were complete or not, which I imagine is something that you're going to then be looking at as well with a particular carrier. How many complaints may have been filed or rulings saying they didn't do a complete investigation, to use that to then buttress your argument.
Yep. And we've used that. I've become much more in tune with the insurance department over the past couple of years as a result of some litigation where we've had to subpoena them and speak with their counsel and kind of really find out the ins and outs of how they work over there. So with that knowledge, we're able to get a lot more information that might not be available to other attorneys or certainly the public because of those connections. So it allows us to do that dive from that side of the equation to figure out what is happening with the insurance department and these carriers in these claims.
So what type of information are you looking to get from the departments of insurance, just kind of generally speaking, that you're then going to be able to go back to the carriers for something like, a COVID-19 or, any other larger, we'll call it an industry issue, whether it's appraisal, overhead and profit, depreciation, fill in the blank there that's going to say, hey, here's the information that is available that we're getting that carriers maybe don't realize what you're doing on this side.
Yeah. So, through some of the connections that I've got over there, it'll usually start with just a phone call to say, hey, what are you guys seeing when it comes to these complaints? Or is it a huge volume that are coming in? Is it, just a few here and there? The insurance department, the one thing I've learned is they hate subpoenas. They really don't want to respond to subpoenas. They'll try and quash them as much as they can. But they'll also offer up information if it's something that they can just pretty easily give to you with a phone call. So what I would be looking for is the number of the complaints, and more specifically, any complaints where action was taken. So it's not usually enough for me to just say a complaint was filed. In our world, anyone can file a complaint for just about anything. Whether or not it has any teeth is really the question. So what I'm most curious in is what complaints were filed on this and how many of them were was there actually action taken by the insurance department to investigate, to force change, to do something like that?
Okay. Um, in Pennsylvania, at least, I know the Department of Insurance has largely stayed out of the business interruption fight. They're not taking a position one way or another on coverage. There are a lot of legislators out there, Pennsylvania, New Jersey, New York, Massachusetts. I could go on, the different states where they're trying to enact legislation saying business interruption is not, being offered. You need to extend coverage for this. Some people I've heard argue that, well, that's almost the equivalent of an admission by a governmental body that these policies don't provide coverage for these. Again, broad sweeping strokes. I kind of bite my tongue till it bleeds when I hear them talking about this. How do you respond to something like that, where they're saying, look, because they're doing this, that must mean that there is no coverage under these policies, period, case closed, end of story?
There's a lot of problems I have with
and I do too. I will tell you that.
Yeah, with the government officials doing it. Look, for just on a constitutional level, on a law level, I don't think they have the authority to force the carriers to make payment on things that they didn't contract for. I don't think that would be upheld if it was actually contested. However, they are the people. When I talk about lawyers who don't know what they're talking about in this area, politicians are like 10 steps behind those lawyers that have no clue what they're talking about. They just hear these statements, and it's a publicity. I truly believe it is a publicity stunt, that they just wanted to show their constituents, look, we're trying. Right. We've had a number of state legislators across the country send out letters that in essence say, hey, carriers, you should cover this. It's not an order. It's not, law or anything. It says you should do this. And then these letters get posted out and say, hey, look, we care about you. We care about our constituents. We care about you guys. Look what we're doing. And some have gone further. They're drafting bills in Pennsylvania and New Jersey now. The focus on them, and I've had a few conversations with some of the legislators on this, because I've testified for the legislator before. They called and they said, well, how do you go about doing this? And the focus needs to be on the only way you can get away with it is if the government is the one who's actually paying the money, right? So if the carrier is going to pay this, the bills, the way they're being drafted now is the carrier pays it and the government pays them back. Maybe, right? It's a mess. But to say that because the government is saying these things, that means the policies don't cover it, is equivalent to my 5-year-old niece saying, "Oh, insurance companies, this isn't covered. You should pay for this." It literally has no weight to me whatsoever.
And I don't think it would have that much weight to a court either. But there are some, the right circumstance. We both know this, where a judge may look and say, "Okay, you know what? I'm going to give that a little more credit." I'm in your camp on this one. I don't think that has or should have any weight whatsoever to whether there's coverage here or not. But here's the other thing I want to ask you about. In some states, you could be right on the coverage, but really act in bad faith in the investigation and win on one and lose on the other, right?
Yes. And it's always frustrating, especially for a lot of my clients, when I tell them, look, without a breach of the contract itself, right? If they were right on the coverage decision, and there's really no breach of the contract under those forms, the bad faith claim becomes so much harder. And you and I both know this, and courts have tossed out a few of our cases because there was no breach, thus the bad faith can't stand. And it becomes frustrating for the insureds to say, well, they still put me through all this. What's the deal here? I think the courts are going to take a much closer look at these cases because of the widespread nature of it, because of the likely publicity that is behind every opinion that comes down on these for the next, year or two. I think that will result in some favorable slides, probably in the plaintiff's direction. But in the end, just on a common sense level, it does make it difficult, not impossible, but difficult to argue that an insurance company acted unreasonably, and they knew they were acting unreasonably, but did it anyway when they made the right decision, right? It's one of those things that just doesn't make the most sense off the cuff.
Right. Unless you find something in one of these other, states or jurisdictions where there is that great piece of evidence where someone produces something internally from a carrier that, and I'm just going to make this up, says, here's the exposure. We can deny X number of claims and save us this amount of money if we do it at this point, or just something that really shows they're putting their interest over the insured's interest. To my knowledge, I haven't heard of anything like that. I haven't seen anything like that. I will candidly say that. But there are lots of insurance carriers out there.
Sure.
There's a lot. There's a lot of complaints that are alleging premeditated patterns and practices and coordination and things I'm not quite sure are true, but if they are, could be, something that promotes a lot of litigation for a lot of years to come.
Sure. And all it takes is that one kind of accidental leak or purposeful leak to kind of start triggering that snowball. The cynical side of me and my side of the practice always thinks that these insurance companies have some grand scheme plan and behind the scenes work that is denying these claims that they know shouldn't be denied. I actually did have one case, and it's confidential, so I can't speak much about it. But there was an accidental email that was sent by the carrier to the adjuster, the public adjuster in the case, that clearly showed they were manipulating the file, and it settled as soon as we disclosed that email. But that's the kind of thing that you look for to say something slipped through the cracks in one of these cases, in one of these discoveries. It got through. And now it's going to create this snowball of litigation because the information's out there.
Do you think carriers have seen even I don't want to say the beginnings of these business interruption claims yet, but really seen a lot of them hit? Because, as I'm thinking about this through, I'm saying most businesses are closed. They're slowly maybe starting to reopen. The public adjusters are largely closed as a result. So until they get open, or at least are given the clear to open, we don't know the true extent of volume we're talking about just in terms of claims. I mean, we watch the news and see the numbers they're guessing at there in terms of projected losses. But for, where you and I practice, I think it's largely an unknown at this point.
Yeah,
you may have
I don't
people
think
consulting you about is there coverage or not, but in terms of getting from, hey, I'm closed, do I have this potentially, to I'm now submitting a claim for it, or I've got representatives working and advocating on my behalf for it.
Yeah, I don't think we're even close to the number of claims that are going to be filed on this. Even on the ones that I've reviewed, I mean, we've probably looked at 100 plus policies at this point. The insureds come to me and say, look, do I make a claim now? Do I wait until I get back and know what my damages are? Until I know what my business is going to be like? Why would I make a claim now if I don't know what's going to happen down the road? And those are just the ones that come to me. I mean, I imagine that thought process is exactly what's going on for every business owner, that they don't know what the loss is to them until they can open up and really figure it out. So I don't think we've scratched the surface at all.
Now, let me ask you about something else here, because again, a lot of this is what I'm seeing online, and I figure between you and I, we're the best ones out there to talk about it because we're living and breathing this stuff for a living here. There's been a fair amount of discussion about, okay, whose responsibility is it to actually show there was a virus in here? And I think that comes into play more when you're talking the civic authority issues and whether it's covered or excluded. But then again, I'm seeing a lot of people say, well, this is all on the insured. If they want to show that there's coverage for civic authority shutdowns, they need to prove that there was, the virus either in their property or in the location. And this is the part where I'm looking at the shutdown orders, the ones from Governor Wolf or in New Jersey, where they're saying we're shutting these counties down because there is known cases in the county there. I mean, am I looking at this kind of the right way? Do you think some of these other attorneys are maybe not following through the way they should be? And again, I'm not throwing names out here on purpose, but just from a general concept here, because I think this is such an important thing, and it's going to be part of our dialogue going forward.
Oh, I agree completely. It's going to be critical. This one of the most interesting things about this, and what this will bring light to, is how to really interpret an insurance policy. Because this isn't going to be as easy as saying, "Here's your broad all risk language coverage. Here's your exclusion. Let's figure this out." There is so much bouncing back and forth between exclusions, exceptions to exclusions, coverages, that it's really going to be a deep dive into policy interpretation. So, as you know, I've got the burden to prove the all risk language. I've got to prove there was either direct physical loss or damage, or, as a number of policies say, risk of that. You've got to prove an exclusion. So if it's just a straight virus exclusion, then you've got to prove that. If there's additional coverage, now it's going to shift likely back to me, based off of most of the courts in this area, at least, to prove the additional coverage. And then the real question becomes, to trigger that additional coverage, is it going to be enough for me to say there was civil authority that did this, or do I need to prove all of the prongs under civil authority, or is it the defense that has to show that an exclusion would apply to the civil authority coverage that I'm now showing? I mean, it's really going to be intellectually stimulating to try and decipher these cases and these policies, but that burden shift is going to be something that is very heavily litigated.
Now, do you
over the
think
next couple
that's a
years.
situation? Do you think, Tony, that's a situation where the insureds may actually have an easier time showing a reasonable expectation to say, look, here's this provision. It says civil authority shut down. The government told me to shut down. There are cases in my town or in my county. Coverage exists. That's what I expected.
Absolutely.
Is that the easier road to go down?
To a degree. So a lot of it's going to depend on the language of the civil authority provision, because, again, just like we've said this whole time, all these policies are different. And you're going to want to read the civil authority language specifically. But if this isn't a civil authority shutdown, what is? Right? Like, I mean, this is so clearly the action of a civil authority to stop your business. So I think just on its face, as that phrase relates to coverage, I think you've got a reasonable expectation. You said, wait a second, my policy says I'm covered if the civil authority shuts down my business. It shut down my business. What are you talking about? Now, as you and I both know, that civil authority is contingent on a number of other factors, right? It needs to be as the result of a covered cause of loss at a property, in some policies within a mile, other policies within, an immediate circumference around the building. I mean, there's a number of different definitions of where it is. So you've got a few prongs that have to be met. It's not as blanket as just civil authority shutdowns. So once you've got covered cause of loss, now we go back to, okay, we've got a civil authority shutdown. Check. Was there a covered cause of loss? Covered cause of loss under my policy says risk of direct physical loss or damage. We've got, it's got to be within 1 mile. Well, throughout that entire mile, there's risks of damage as the result of this virus. Or even better, there is the actual virus. Great. Now we might have a good argument for coverage. I still believe that's probably going to be my secondary argument, to say I don't even need to get there if I can just show that the virus is risk of direct physical loss or damage. But if you're going to claim an exclusion, well, now I've got this additional coverage. There's an important thing to note for anyone that listens to this. In any jurisdiction, take a look at what the law is on whether or not the exclusions will apply to things like additional coverage. The states have taken some pretty polar opposite opinions on this, depending on the court you're in. And there's some really good case law out there suggesting, or even just blanketly stating, that if there is a conflict between an additional coverage and an exclusion, they're gonna weigh on the side of the insured and provide coverage. So if you've got a virus exclusion in the general exclusions, and then you've got your additional coverage for civil authority, and it doesn't specifically say that the exclusions apply, you're going to have a good case to say, well, the virus exclusion doesn't apply to my civil authority additional coverage.
How about this for a defense? And this is kind of something that I've been thinking in the back of my head here. Let's say you have the business that shuts down, but doesn't apply for a waiver. is that a potential defense to that civil authority claim to say, look, you had the ability to apply to reopen, but you didn't take advantage of that? There is no coverage that would exist under the civil authority. Now, it doesn't apply to everything, obviously. I mean, there are some businesses that are clearly shut down, but I could also see a situation where someone says, hey, under a policy, you've got not only a duty to mitigate your loss or damages, but you also had the ability to ask the governor, local official, whoever it was, for permission to reopen.
That's actually a really interesting thought. I hadn't thought about that one. The one I had thought about was, well, what if people don't apply for these grants? The SBA loans, the PPP loans. If they're not applying for those, would that be a failure to mitigate, at least to reduce damages down the road? But yours that you could actually apply to get an exemption from the shutdown order is an interesting one. I think that most likely falls on the reasonableness of it. I think because most of the language in the policies, you got to take reasonable steps to mitigate your damages. So it's not absolute, right? You don't have to do everything to mitigate your damages, just whatever's reasonable. And if you've got a policy holder that says, wait a second, I own a shop, like there's, why on earth would I have thought that I could be exempt to allow people into my shop to go shopping? There's, that might be enough to say that they didn't need to do it. But, then you've got other ones like, what about like an accounting firm, for example? You don't really need face-to-face contact to run an accounting firm. They can mail you the tax documents. You can do your job a distance, mail it in to be filed. But if that office itself was shut down, could they apply for exemption? Maybe. It would be interesting to see that argument play out.
See, the other point you brought up was one I hadn't thought of with the SBA loans. Let's say a business does apply for the SBA loan and tries to submit an insurance claim. Are they under an obligation, if they get the SBA loan, to tell the carrier, hey, I've already received X amount of dollars to keep my business afloat, and because I haven't laid anybody off, the loan will be forgiven? And what happens if they don't make that disclosure? Or can the insurance carrier, I don't want to say hold up a payment, but basically contingent a payment on whether they get the loan, how much they get? And again, we're all assuming that coverage exists for the loss, but like you noted early on, there are policies that do give coverage for this. And, some of the lawsuits out there, do give coverage for it. I will say, based on what I've seen in the policy language and how the complaints have been written, yeah, if they're all accurate, there's going to be coverage for that.
Yeah. I think they're going to have a responsibility to disclose that. I think it would be wrong of them to try and, because it's going to be a double dip, right? If they get the SBA loan and don't have to pay it back, it'll be a double dip on the lost funds. So how the carriers handle that will be interesting, because for the option, because they've got two choices, right? They either hold the money until they know if the loan gets paid back, which I'm sure is what the carriers will do, or they pay it and say, if the loan does not have to be paid back, you've got to pay us back. I just can't imagine a carrier doing that. So I think the way it plays out is the carrier will say, well, look, you had $1 million in loss. The government gave you, 500,000. Here's 500,000 to make up the difference. And if you have to pay that other 500,000 back, let us know, and then we'll supplement the rest. I assume that's how it's going to play out.
Now, let me ask you this as well. Broad sweeping question here, Tony. If you had, 1 to 2 minutes to say whatever you wanted to the insureds out there who are going to be listening to this, the small business owners, the large business owners, we're not leaving those out as well. The individuals who have their own accounting firm, like you were just talking about, the law firms, who may have business losses, you name it, as it relates to COVID-19 and these business interruption issues. What would your message be to those folks?
The biggest thing I want everyone to understand is that every policy is different. I've probably said it 5 or 6 times on this podcast alone. But you need to get your entire policy. Your renewal packet is not your entire policy. Contact your agent or your insurance company, ask for a certified copy of your policy, and then send it to a professional to review. They're long. Your business policies are often 200 pages or more. Send it to someone who knows what they're doing so they can review it and put a claim in. I'm pretty much telling everyone, at least document that you're putting a claim in, whether you think it's covered or not. And when you present it, as long as you've got the guidance of somebody who knows what they're doing, whether it be a public adjuster or an attorney, if it's presented the right way, you're at least protecting yourself down the road if changes occur, if government action changes things, if courts change things, and put the claim in the right way. But know what your policy says before you do it, because you don't want to end up putting a claim in for, let's say civil authority, if your policy for whatever reason doesn't have the civil authority coverage. I mean, I've seen some that have been policies that have been renewed from the 80s and are still in effect that don't have civil authority coverage. So you've got to be really careful with that information and to make sure that you are contacting someone who knows what they're doing before you put that claim in. And the second aspect is, just because the insurance company says it's not covered doesn't mean it's not covered. The only reason I have a job is because I disagree with what insurance companies say. So what they say is not gospel. And you can fight that as long as you've got a fightable case. So work with someone that knows what they're doing.
Now, I'm going to flip it around a little bit, Tony. Are there any messages you would convey to the insurance carriers out there, as they're getting these claims in or are contemplating a response to these different, scenarios, that you'd like to say, hey, speaking as the voice of the insureds, for the little guy out there, here's my warning to you. We're not saying, I'm threatening you with lawsuits, but if there's things that you could say that, hey, you better not be so hasty with this, what would you say to them?
Well, first, I wouldn't say it as a warning, right? I sometimes these aren't covered. Look, I recognize some cases just are bad claims. They aren't covered. And people should recognize that, and insurance companies should recognize that. But the important thing here, and really with every claim, is to just do your due diligence, right? Do your investigation, at least document everything so that everyone can go back and say, okay, here's exactly what you did. You took all the steps you needed. Maybe your decision was wrong, right? Maybe you fell on the wrong side of it, but you at least did everything you were supposed to do. You made it a reasonable decision here. Making decisions without that investigation, making those blanket statements that this isn't covered under your policy, regardless of what the facts of the loss are, is just too risky. It doesn't add enough benefit to the carriers to say, we warned people this wasn't covered. It is only opening a door to further litigation. And if they do that, if they really do the investigation, and if they really recognize the harm that people are suffering through this, and make them feel like, look, we really do care. We can't cover everything that, that's just not the nature of insurance. This policy doesn't cover it. Here's everything we did. We will keep open communications with you until you understand our position. If you don't agree with it, that's fine. That's your right to not agree with it. But I want you to understand our position. And I think they'll see a lot less litigation if they do that, because a number of people will believe it. Even if I disagree with it, I think people will believe it. And I think it'll limit the damages that they are susceptible to just that breach of contract, so that they don't have to worry about all those extra contractual damages.
Now, there's one thing I want to kind of wrap up us talking about today, and it was a copy of a complaint I forwarded over to you this morning. And it wasn't in Pennsylvania. It was in, I think, Illinois there. But one of the things that struck me about the complaint was the claim was looking to have the coverage issue resolved by the court, but then the damages resolved via appraisal. Now, I want to bring that to Pennsylvania because appraisal has been a big issue for probably the last 5 years. But I also know that there are some carriers who have taken the position, either in one case or broadly speaking, that they're going to resolve coverage issues by appraisal. Do you think that is something that if they turn around now and say, well, no, we're denying these claims and we're not even going to go to an appraisal, that insureds can turn around, or someone like you can turn around and say, hey, wait, you've had this practice of doing this before. Gee, appraisal is a good avenue for me to take a shot at here. Let me go and try and force an appraisal on the issue. And I'll be the first to say, Pennsylvania business interruption claims are appraisable.
Mhm.
As a general matter, that's the Ice City case from back in the 50s or 60s when that case came out there. That's a non-starter, but it's the whole, do you go to coverage, or are you able to put coverage issues in appraisal or not? And I guess my question to you is, if you've got those carriers where they've gone to appraisal on coverage issues, are you more likely than not to say, hey, look, you need to put this in appraisal, and here's my appraiser who is, let's be fair, going to say, this is covered and here's the number. And then you're going to have the insured's appraiser who's going to either say something different, or they're going to say, it's not for me to handle.
I don't believe, if there's a full denial, I don't believe any carrier is going to be responsible to go to appraisal. When we get into this fight of what's appraisable and what's not, in every case that I've handled, at least, there has at least been some level of coverage, right? Even if it's small, it's some monicum of coverage to trigger the policy coverages and say, okay, we've got a covered event. And this has always been plaintiff's position, is everyone is in agreement, policyholder and carrier, that a covered event occurred. Now the question is, what damage resulted from that covered event? And that is when you get into scope and what we call scope issues and coverage issues. If a carrier in the past has sent a full denied claim where there's no coverage at all to appraisal and bound themselves to that response, there is an issue for them, in my opinion, of how these will be resolved in appraisal. Because if they've shown a pattern of practice of a willingness to do that, it's going to be pretty hard to backtrack and say, no, we're not doing it for this case. But again, I haven't really seen that happen, and I don't know if you have either. But when these get argued, it's more, all right, well, wind did damage one side of the roof. Did it also damage the other? Is that a scope issue? Is it a coverage issue? That's the stuff we fight over. Not so much is appraisal appropriate for a case where the carrier is saying all of it's denied and we're saying it's covered.
Mm-hmm. Yep. All right. Last thing I want to ask you about here relates to this. All right. And I saw this in another lawsuit recently where the insured wasn't looking necessarily for coverage for the business interruption claims, excuse me, but for food spoilage. Mm-hmm. And the carrier took the predictable decision, from maybe on whatever advice they did, and said, nope, it's not a direct physical loss, period. There's no coverage for that, or viruses are excluded under the, a contamination exclusion. And but when you read the policy language, you say, hey, wait a minute, this is different. Are you looking at these with that kind of fine-tooth comb as well? And is that something the insurance carriers and the insured should also be looking at, not just the big picture, but okay, the different aspects of the insured's business that they may have a loss? Because if they don't have the full business coverage, but they have $50,000 worth of food that was destroyed, or they had to discard because they had to shut down, well, something's better than nothing, I guess is kind of how I look at it. And I'm interested in what your thoughts are.
Yeah. So a few questions in there. I think first, we are looking at them with that fine tooth of a comb. So two areas that we are pretty universally telling everybody should have coverage. Food spoilage is one of them. So we deal with a few large hotel chains and restaurants that have had food spoilage as a result of this. And we've advised them that under their policies, almost every time I look at the policy, it's going to be covered, either based off of the language of the additional coverage or an endorsement within the policy. A number of the policies either specifically state certain exclusions don't apply to food spoilage, or they'll do a carve out in essence for the food spoilage coverage. So I think at least from a carrier's perspective, if you want to try and start avoiding some litigation, the insured that you can pay, $20,000 on a food spoilage when they've got $1 million claim. If that is enough to just tell them, look, if you're satisfied with that, we pay it. They should make a strong consideration into doing that. But it's not just that. The other aspect that we're seeing is on the liability side. A lot of these businesses have umbrella coverage under a second policy that has liability that doesn't exclude any of the loss that we're talking about here for viruses or for anything else. So if you have a company who has a large liability loss, you can most likely get coverage for that under these policies, especially under the umbrella policies that are tagged on. So, when we're looking at these, we're not just looking at the first party, homeowner or first party business policy or commercial policy. We're looking at all of it. And we're trying to find anywhere in these that we can get our clients at least something to help through this process.
All right. Well, Tony, thank you again for taking the time. It's nice for you and I to, ditch the suit and tie for a little bit and the mountain of exhibits. And, to everyone out there watching, look, this is proof positive that you can have two attorneys who litigate cases against each other frequently, actually get together, have a good civil discussion, and actually have a lot of areas where we'll agree on and say, here's where, the issues lie. Yes, there's this area, yes, there's that area, and then here's the gray in between. So thank you very much for taking the time today to appear on our special podcast of The Defense Never Rests, COVID-19, the insured's perspective. I really appreciate your time. I'm sure your clients, the people you deal with, are going to appreciate the messages that you've said here today. I certainly know the people that I deal with are going to appreciate that as well. And, hopefully they'll take it to heart, and you and I won't see each other on a lot of these cases here.
Let's hope, Scott. I really appreciate you letting me come on and do this. I think it was a really good discussion to have. And hopefully, like you said, people take it to heart and realize that, there are options out there and that maybe these can be resolved without you or I getting involved.
All right. Tony, thank you very much to everyone. Again, please follow us on Apple iTunes, on YouTube, The Defense Never Rests. Give us 5 stars, especially for this one, because I think you're going to find information here that you're not going to find anyplace else out there. I mean, the ability to talk to and hear from someone whose firm is leading the way in terms of the COVID-19 analysis, who specializes in this particular area. Tony DiUlio of Wheeler, DiUlio and Burnaby, my counterpart, so to speak. I'm Scott Ribney of Morgan and Akins, who does this on the defense side here. Thank you very much, and I hope you enjoyed the podcast today. Tony, take care.
You too.